Hi, my name's Abby Faterick, and this is my Educational Leadership School Law course case brief number 2, due on November 1st. For this assignment, I chose the Campaign for Fiscal Equity versus the State of New York case, which was decided on November 20th of 2006. One of the main reasons I chose this case is because of where we are in the world today with the pandemic and funding issues and how it's affecting schools, just beyond even the health issues, but also how we're going to keep paying for things. So in looking at CFE versus the state, it brings up the 14th Amendment, which states no state shall deny a person within its jurisdiction the equal protection of the laws. So how does that influence education, which is left mainly to the states to determine? So we're looking at funding equity here, not necessarily equality, but equity. Here's some background about the case. The 2006 case is the third appeal of CFE against the state. In 2003, the Court of Appeals found that the New York City public schools were lacking funding and children were not receiving the constitutionally mandated opportunity for a sound basic education. In its previous hearing of this case, CFE2, the Court of Appeals said that they defined sound basic education as the opportunity for a meaningful high school education, one which prepares children to function productively as civic participants. In 2004, the state estimated a minimum cost of $1.93 billion was needed in additional operating funds to ensure that the New York City public schools children were provided a sound basic education as previously defined. The way that the amount of $1.93 billion was determined was by the Standard & Poor S&P School Evaluation Services, where they calculated the additional spending required using a successful schools model that studies the expenditures of school districts with a proven track record of high student performance. And this method had been used before by the New York State Board of Regents in how to determine state aid for districts previously. One of the ways that S&P determined this was to use a cost effectiveness filter, where once they ranked all of these successful schools, they only used the lower spending half to create the average, because the Board of Regents had noted previously that districts that perform at the high levels often have a very substantial wealth base, so it wouldn't be fair to use those in determining how much money is needed. Some more facts of the case and background is that the state was given until July 30th, 2004 to implement these measures, and the Supreme Court was to determine its compliance. So to do this, the Supreme Court used a panel of 3 referees to determine if the state followed the case. So the legislature did not pass a bill until August 10th. Therefore, the Supreme Court determined that they needed to look into this, and the referees rejected that cost and effectiveness filter that was used by S&P that I just mentioned, and said, no, the actual cost would be $5.63 billion that is needed, not $1.3 billion. So the Supreme Court said it needed to be up to $5.63 billion, and that the New York City Department of Education needed to now develop a comprehensive plan for that amount. And that leads us to where we are in this case with the third appeal about how much money should be given for New York City public students to receive a sound and basic education. So the actions sought are that CFE wants New York City public school funding to increase so that all students receive that education, and the state says that it's already giving the funds that are adequate for a sound and basic education. So the Court of Appeals is left to answer: 1, should the Supreme Court have used the judicial referee's report and recommendations? And is the amount used by the state, $1.93 billion, enough to ensure, or is it the $5.63 that the Supreme Court just stated? At the end of this, the answers given were, for the first question, no. The role of the courts is not, as the Supreme Court assumed, to determine the best way to calculate the cost of a sound basic education in New York City schools, but to determine whether the state's proposed calculation of that cost is rational. And for number 2, yes, they declared that the funds of just $1.93 billion, which now would be adjusted to fit the 2004 inflation rate, is enough, and that it does not need to be the $5.63 billion that the Supreme Court found with its referees. So in looking at question 1 about the Supreme Court and their use of the referees, the opinion states devising a state budget is a prerogative of the legislature and executive. The judiciary should not usurp this power. The state, not the Supreme Court, was ordered to ascertain the cost of a sound basic education in New York City. And in referring to question 2, the opinion states the use of the cost effectiveness filter is rationally defensible. New York City could attain minimal constitutional standards while spending less than this higher spending group of successful districts. We cannot say they are irrational. So the significance of the case today is about financial equity and how this is still being brought to the courts today. For example, there's a case called Cook versus Raimondo in Rhode Island about the state not providing an education that adequately prepares students to participate as informed citizens in civic life. And that was most recently discussed in December of 2019. There is also a recent case in Michigan called Gary B. versus Snyder. And the complaint alleges the state's systemic, persistent, and deliberate failure to deliver instruction and tools essential for access to literacy in the plaintiff's schools, which serve almost exclusively low-income children of color, deprive students of even a fighting chance. And there is yet another example in Mississippi where the Fifth Circuit Court of Appeals is hearing a case that argues for underperforming schools that predominantly serves Black students, and it says they lack textbooks, literature, basic supplies, experienced teachers, sports and other extracurricular activities, tutoring programs, and even toilet paper. So this is one that has made it to the federal courts that is going on in Mississippi, like I mentioned. In looking at this case more holistically and historically, we have to look at how have and how will courts treat cases of educational financial inequities. So in this specific case, we're looking at the majority determining that the case supports leaving this to the executive and the legislators. However, I think it's important to bring up Chief Judge Kaye's statement where she dissented and wrote, "I must dissent because the majority does not resolve the inadequate funding of the New York City public schools and reaches a result that is well below what the governmental actors themselves had concluded were required." So the S&P report states several times that the measures that they use and the weights that they apply and the filters that they used should not be taken as the only solution, and that there is a big range of what could be used. Specifically, S&P stated that they do not recommend ending spending level or the adoption of any particular achievement scenario. So they reported a wide range from $2.45 billion to $5.57 billion, which translates to the $1.93 billion in New York City, or 4.69 overall. So I think that this case brings up an important point of how judges and courts have a hard time determining what the states and local districts should spend their money on and how it should be spent, and how we even attempt to keep these things fair. So CFE versus the state of New York was influenced mainly by a case almost 50 years ago called San Antonio Independent School District versus Rodriguez, which was decided by the U.S. Supreme Court in 1973. It challenged a funding scheme through state money and local property taxes by arguing that this system underprivileged students that resided in poor districts. How did the 14th Amendment get violated or not in this case? And the result was that no. This court said no fundamental right to education is in the Constitution. The Equal Protection Clause does not require absolute equality or precisely equal advantages. So since that court case was done almost 50 years ago, 45 of the 50 states have had school funding lawsuits filed. The second point is that CFE's work improved school funds, but only for about 2 years. Once the recession of 2008 took hold, it froze the state's education funding, and as of 2020, New York State still has not provided the New York City school districts with all the funds promised. So the last point here is that the funding battle is mainly fought at the state level, but federal aid is needed. States and localities provide the primary funding for K-12 education, and we have to look at cuts that have been made to this due to COVID-19. And federal investments were made into the CARES Act, but not enough to make up for the deficits. So we're looking at how this is really going to play out in the future as well. If you're interested in this topic, I have 2 articles that I suggest reading that give you a little bit more background and insight into education funding. The first is a 2016 article from The Atlantic, and the second is a 2019 article that brings up some of the political influences that are also going on right now. Thank you so much, and let me know if you have any questions. I look forward to hearing your feedback.